Hello and welcome to BYJU'S Exam Prep IAS. Let's get started and look into our daily quiz. Before we start with the practice questions for the day, we have an announcement. Byjus has launched the Mega Scholarship Program. You would be able to avail as much as 60% discount on all our live online classroom program and offline classroom program. We have very limited number of seats, so this offer will be valid only till 30th of May only. All that you have to do, click on the link in the pinned comment and register now to get a callback from our counselors so that you would be able to avail the discount. Let's get started and look into the first practice question. Which of the following statements are correct? Hiroshima was the first city in the world that was hit by a nuclear weapon. Potsdam Declaration was issued by United States, Great Britain and China in 1945 calling for the unconditional surrender of Japan. Which of the statements are correct? The answer to this is both. Why have we taken this practice question? Because this article on the PIB makes a reference to Hiroshima Peace Memorial Museum, which is why we have taken this practice question. Let us try and understand what are these statements. When you look into the first statement, Hiroshima was the first city in the world that was hit by a nuclear weapon. This happens to be the right statement. When was it? This happened on 6th of August. So 6th of August is also called as the Hiroshima Day. Followed by this, after 3 days, the second city was hit by a nuclear weapon, and this was on August 9th. 3 days immediately after Hiroshima was bombed, 3 days after this, Nagasaki was hit. So Hiroshima happens to be the first city in the world, and Nagasaki happens to be the second city in the world. After this, there have been no nuclear weapons which have been employed. So the first statement is right. When you look into the second statement, Potsdam Declaration was issued by United States, Great Britain and China in 1945 calling for the unconditional surrender of Japan. Yes, this statement is also right. So remember, Potsdam Declaration is with respect to the surrender of Japan. What exactly was happening? During the Second World War, we had the aggression from Germany. So you had the Allied powers which wanted to control Germany. Germany, under the control of the Nazi government, was also making sure that it was developing these nuclear missiles. And as a result, United States of America also was developing nuclear weapons as well. On one side, Germany was almost in the surrendering phase. It also wanted a peace treaty so that there is not much indulgence in the war as well. But on the other side, in the Pacific region, Japan continued to be aggressive. Japan continued to haunt all these allied powers. It continued to be aggressive in order to teach Japan a lesson. United States of America, which was developing the nuclear weapons, made sure it bombed Hiroshima and Nagasaki. Why Hiroshima and Nagasaki? That is primarily because this happened to be a region where major military activities were taking place. So United States of America bombed Hiroshima on 6th of August by a nuclear weapon called as Little Boy on Hiroshima. Little Boy was the code name for atomic bomb dropped on Hiroshima, which was a uranium gun type bomb, and 3 days after this it also dropped bombs in Nagasaki as well. This led to as thousands of people getting passed away. 9,000 to 1,46,000 people died in Hiroshima. The city was completely devastated, and in order to make sure that such nuclear weapons are not used in the future, what we had was Japan create this Hiroshima Peace Memorial Museum. So this is a symbol that was created by Japan so that people realize the ill effects of nuclear weapons. And also note, there is a word called as hibakusha. Hibakusha is a word of Japanese origin, and generally it is related to people who are affected by the atomic bombings of Hiroshima and Nagasaki. Now let's look into the next practice question. With respect to scheduled castes and scheduled tribes, Prevention of Atrocities Amendment Act of 2018, which of the following statements are correct? Preliminary inquiry should be conducted before registration of an FIR. Persons accused of committing an offence under the 1989 Act will not be eligible for anticipatory bail. Which of the statements are correct? The answer to this is two only. Why have we taken this practice question? Because this article on the Indian Express makes a reference to SC/ST Prevention of Atrocities Act of 1989. Let us try and understand what are these statements. When you look into the first statement, preliminary inquiry should be conducted before registration of an FIR. This statement is wrong. We have one of the important laws in our country, which happens to be Scheduled Tribes Prevention of Atrocities Amendment Act of 2018. This was introduced by the government. The original act happens to be 1989 Act. What we have is an amendment introduced to this act in the year 2018. What is the background to this? One of the cases was filed in the Supreme Court of India. The Supreme Court of India came up with a verdict that in case there is no prima facie case, then it is the police officers who have to inquire and only then arrest a person with respect to atrocities against the SCSTs. So what if an atrocity is conducted as of that day? What we had was a law that irrespective of what happened, prima facie evidence need not be taken into picture. So if an atrocity is connected against the SC or the ST, that particular person would have been immediately arrested. But what did the Supreme Court say? Supreme Court said that there have been ample number of examples where it has been misused. So what should the police officers do? Prima facie, they should be able to see if there is a case that is made and only then make an FIR. This was the judgment given by the Supreme Court of India. But then we had what is called as the legislative overruling that was taken up by the government, by the parliament, and they introduced changes which said that preliminary inquiry need not be conducted before registration of an FIR according to the Amendment Act of 2018. So they introduced the amendment which said that prima facie they need not have to investigate if there is an atrocity that is committed against the SCST. You don't have to investigate. Go ahead, register the FIR, said this Amendment Act of 2018. So the first statement is wrong. When you look into the second statement, persons accused of committing an offence under the 1989 Act, that is the Amendment Act to the Mother Law, will not be eligible for anticipatory bail. Yes, this statement is right. These people who have committed atrocities against the SCST Act will not be given anticipatory bail under section 438 of the CRPC. So the first statement is wrong, second statement is right. So the answer to this would be 2 only. And do note, this entire process that we are speaking about is what is called as legislative overruling. What is this legislative overruling? We have the Supreme Court of India which should have passed a judgment. So we have the government of India which comes up with an amendment to the law or to the constitution, basically to overrule the judgment of the Supreme Court of India, which is called as legislative overruling. So there is a ruling by the Supreme Court. So the legislature makes a law against the judgment of the Supreme Court by introducing an amendment in the law. The very first time where legislative overruling came into picture happens to be in the state of Madras versus Srimati Champakam back in the year 1951. Also, as part of the assignment, give previous judgments which have had the legislative overruling is what you have to put on the comment section. Now let's look into the next practice question. The third schedule of the Indian Constitution contains the forms of oath or affirmation for which of the following constitutional offices: President of India, Union Ministers of India, Supreme Court judges, Comptroller and Auditor General, Governors, State Ministers. The answer to this is 2, 3, 4 and 6. Why have we taken this practice question? Because this article on the Indian Express makes a reference to oath, which is why we have taken this practice question. When it comes to the third schedule, it contains the forms of oath and affirmation for Union Ministers of India, Parliament election candidates, members of the Parliament, Supreme Court judges. Since we have the Supreme Court judges, High Court judges, and equivalent of the central government, what we have is the state ministers, state legislature election candidates, and the state legislature members. And additional to it is the Comptroller and the Auditor General. Do we have it for the President and the Governor? The answer to this is no. Since President and the Governor are not part of the third schedule for taking oath and affirmation, under which schedule or article it is covered is what you have to put on the comment section. In third schedule, we do not have the President of India. We do not have the governors as well. In which article or in which schedule they take the oath or the affirmation is what you have to put on the comment section. Another simple assignment is, what is the difference between oath and affirmation? So there is a difference between oath and affirmation. What is this difference is what you have to put on the comment section. Now let's look into the next practice question. Consider the following statements with respect to Deputy Chief Minister. A Deputy Chief Minister is not a constitutional post and is equivalent to the rank of a Cabinet Minister. The official files that are meant for CM are routed through the Deputy CM. He or she is appointed by the Chief Minister. Which of the statements given above are correct? The answer to this is one only. Why have we taken this practice question? Because this article on the Indian Express makes a reference to Deputy Chief Minister, which is why we have taken this practice question. Let us try and understand what are these statements. When you look into the first statement, a Deputy Chief Minister is not a constitutional post and is equivalent to the rank of a Cabinet Minister. Yes, this statement is right. What do we understand by the first statement? We have the Chief Minister, which finds a mention in the Constitution of India. We also have the Council of Ministers, which finds a mention in the Constitution of India. But does it have a word called as Deputy Chief Minister in the Constitution? No. So this means that there is no word specified in the Constitution which deals with the powers of the Deputy Chief Minister. But why is it given? Is it a statutory post? Again, it is not a statutory post as well. What happens generally when you consider the Indian politics, you would have one of the leaders who is almost equivalent to that of the Chief Minister, in order to make sure that the political privileges are given to this person as well. What we have is this new Deputy Chief Minister or Deputy Prime Minister, which will be given President, or that person would be given that relevant post. So the first statement is right. That is, a Deputy Chief Minister is not a constitutional post. It is not a statutory post, but it is equivalent to that of a Cabinet Minister, and the person takes oath as a minister. The second statement reads, official files that are meant for CM are routed through the Deputy Chief Minister. No, all those files that are meant for the Chief Minister will go directly to the Chief Minister. It is not routed through the Deputy Chief Minister. Any financial extra powers are not given to the Deputy Chief Minister. His powers is restricted to the portfolio that he is been awarded. So this means that any files for the Chief Minister will directly go to the Chief Minister and it will not be routed through the Deputy Chief Minister. So second statement is wrong. When you look into the third statement, he or she is appointed by the Chief Minister. This statement is wrong. Why? That is because he or she is appointed by the governor on the advice of the Chief Minister. So the third statement is also wrong. Now let's look into the next practice question. With reference to India, consider the following central acts: Import and Export Control Act of 1947, Mining and Mineral Development Regulation Act of 1957, Customs Act of 1962, Indian Forest Act of 1927. Which of the above acts have relevance to bearing on the biodiversity conservation in the country? The answer to this is 1, 2, 3 and 4. This happens to be a previous year question from the year 2011. All these acts, Import and Export Control Act, Mining and Mineral Development Act, Customs Act, Indian Forest Act, have a bearing on the biodiversity conservation. Now let's look into the fact of the day. The fact of the day for today's discussion is mitigation investigation. Let us try and understand what is this concept of mitigation investigation. Let us assume for a moment there is a person who's committed a heinous crime. This heinous crime has been investigated, it has been put before the court of law, and ultimately the court of law imposes capital punishment to this particular person, that is death penalty. During this process, a person may have committed this offense for the first time. During this particular process, the court also takes into picture two types of circumstances. One is what is called as aggravating circumstances. The second is what is called as the mitigating circumstances. What is this aggravating circumstance? Let's say, for example, there is a person who has committed an offense, a murder against another individual. So this might have been a heinous activity. Let's go back to the year 2012. What happened in 2012? There was Nirbhaya gang rape case, and there have been number of instances where cold blood murder has also been committed. A large number of people may have been killed as well. Such cases where children, women, large number of people have been killed, it's a cold blooded murder, it has been heinous in itself. Those will be called as the aggravating circumstances. So in aggravating circumstances, this commission of the murder or any heinous offense is heinous in nature. So as a result, the Supreme Court will impose death penalty on such individuals. Now let's take the example of mitigating circumstance. What is this mitigating circumstance? Let's say, for example, this happens to be not a cold-blooded murder. It was not planned. It may have been heinous, but it is not a planned offense. In this particular case, what will the court look into picture? It would see what led to this particular murder or committal of this particular murder. Let me give you an example. Let's say there is a person who is from a very poor family. This person does not have any of the economic resources. He does not know how to live in the normal society. He does not have the educational background. His family background will also be taken into picture. His socio-economic background will also be taken into picture. Criminal antecedents, employment history, psychological history, all will be taken into picture when it comes to the mitigation factors. So mitigation factors basically means that you have death penalty that is imposed on this particular person, but what are the circumstances that will allow that death penalty will not be imposed on this particular person, but instead life imprisonment will be awarded to this person. So all those circumstances, like his family background, his social background, his criminal antecedents, employment history, how he has been brought up, the environment that he has grown in, all this will be investigated. So this investigation that will be taken into picture before death penalty is awarded to this particular person finally is what is called as mitigation investigation. In mitigation investigation, what would happen? The person's background will be taken into picture, and ultimately whether finally death penalty will have to be imposed on this person or it has to be life imprisonment will be taken into picture. So in 1980, we had one of the landmark judgments with respect to the death penalty, which happens to be Bachan Singh versus the state of Punjab. In this particular case, they also came up with what is called as the rarest of the rare doctrine. If death penalty has to be imposed on a person, what the Supreme Court said is make sure that you take into picture the aggravating circumstances and the mitigating circumstances. So mitigating circumstances basically means that you have to check the entire background. Make sure that this is not a cold-blooded murder. Make sure that this was not planned. So taking into picture all these dimensions, what we have is mitigation investigation that will be taken up by the police officers, by the investigating agencies. This will be given to the court of law. If suitable circumstances are met, this person will not be imposed with death penalty, but instead he will be awarded with life imprisonment. This is what is called as mitigation investigation. It is this that we have to understand with respect to this topic. So this is it for today. Thank you for watching. All the best.